me feeling like I'm Akademiks.
For his appeal, and this is his appeal for a new trial. According to him, he did not have a fair trial, and his trial was prejudiced by a bunch of stuff, and he went for an appeal. So let me have y'all listen to a little bit of what his lawyers argued in front of, this appellate court. Okay?
In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to.
Okay, let me keep going through it. So this is an appellate lawyer. They're arguing, it looks like in California, once you get to the oral argument, it looks like, by the way, these are all judges. 1, 2, 3, 4. I think there's supposed to be 5. And I think it kind of works like 3 out of 5.
The result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore.
Yes. So what she's talking about is that remember Kelsey didn't say much on the stand and she was like, oh, I don't remember. But then the prosecutor was allowed to bring in their interview with her, which was like in September. And her interview in September, she stated a bunch of things that she didn't state in court, but it was allowed to be played. And the jury asked for her interview with prosecutors as the transcript more than relying on what she said in court or what she didn't.
We feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand and that Mr. Edison would say that the following day when Mr. Peterson met with him to give Ms. Pete and Ms. Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard he's guilty. And he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson, and he urged the court to not allow such statements in opening. This motion was not granted, and so...
Okay, so again, she's trying to convince these judges why the trial was prejudicial against Tory Lanez and why they need to grant a new trial. So I want to, kind of summarize and give you an update on what Tory's, current appeals are. Now, obviously, he's, hoping for a pardon. I don't think he'll get one. A pardon in a state case could only be granted by the governor. The governor of California is Gavin Newsom. I don't think he will grant Tory a pardon at all. However, Tory had two overall appeals. One was an appeal of having a new trial. Okay? The second one, and by the way, with the new trial, they would vacate the verdict and they would say you would need to retry him, or you would have the option to retry him, and the state could have said, hey, we're not going to try him again, and he would get out. The second one is a habeas corpus appeal. It's an appeal that says granted information that is either readily available or new information, Tory's being held against his civil rights of freedom, and it's without cause given this new information. And habeas corpus is normally considered a Hail Mary because it's usually a way to force the prosecutors or whoever that's infringing on your rights to show proof that them infringing on your rights is actually legal. So they're saying, why is Tory Lanez not free given these situations or these stipulations or these new evidence? And the prosecutor has to respond and say, well, he's not free because we went through a trial and we proved A, B, C, and D. And these are the facts that still exist. And despite any new information he has, that doesn't overturn the fact that we went through a legal and lawful trial, and also that the evidence does point to the fact that he committed a crime. Okay? So there's two ways that he could get out. One, legitimately, is to get a new trial. And obviously, if he gets a new trial, they would probably lean towards giving him bail because when he was going on trial, initially, he did have bail. Right? He only got locked up when he got found guilty. So that's the first thing. The second way would be to, and by the way, they would have to prosecute him again. The second way would have to be that the state fails to show proof that they have Tory locked up legally based on not only the trial, but also the evidence and what it points to. Okay? Hopefully you guys understand it. Now, what an oral argument is, and this is usually the final step of a appeal. When you appeal a trial, at least from the county perspective in most states, it'll go to, in courts, it goes municipal court, which is just like usually regular stuff like jaywalking. It could be traffic violation. It gets to superior court. Usually that's a county level. That's going to have where people commit crimes that are usually felonious in this and third. And at that point, if you get found guilty, you get to appeal it to almost, in federal terms, it goes to circuit court. But in state court, for the most part, depending on what state, it goes to appellate, like basically state appellate court. So appeals court or court of appeals. And they're going to rule on it. If you don't like what they rule, then you go to the Supreme Court of the state. Everything with the Fed. And by the way, after that, you go to the Supreme Court of the United States. everything goes to the Supreme Court of the United States, but they listen to less than 5% of the cases. All federal cases after circuit court, which is their appellate court, you go straight to Supreme Court of the United States. Basically, what I say that Tory's last chance to get out, unless he gets granted a pardon, is these 2 appeals. He's gotten some minor wins, which is he's been allowed to enter certain things that became known to him at a later date as evidence, and for the judge to consider that. Now, this was an oral argument, all right, and this was supposedly was a 3-justice panel, even though I'm seeing 4 here, of the California Court of Appeals. Okay? What is it? To exonerate him. All right? And his team was trying to say that the trial was unfair. The prosecutors are going to come back and say, no, it was fair, and everything that was done right. So that's where you're listening to the oral argument. They've submitted what's called briefs. They've submitted all these other supplementary information that the judges have reviewed. And this last oral argument is the last thing before the judge rules, or there's a ruling from the panel. And this might take a couple of weeks before they come back with it.
Going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith?
Now, in this appellate oral argument, it's less formal than a court proceeding during a trial. You see they're asking her questions, and she could answer the questions because, again, this is oral arguments.
You believe that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate, but in this case, with these particular facts, I do feel that it's inappropriate.
Okay, let me just move a little bit further into this. But again, this is Tory Lanez's lawyer or appellate lawyer trying to argue for a new trial, right?
Basically, the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did, because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But
so Tory Lanez's account responded to something, and I think it was almost like clearing Kelsey's name. And the prosecutors basically said, yo, Tory, you on social media, you're saying Kelsey didn't do it, but now your legal team is trying to point to the possibility that she did do it and you didn't do it. No, you already tried to clear her name. And Tory's appellate lawyer is saying, well, that was Tory's social media manager who posted that, not Tory himself.
Many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you've said.
Yes.
Were there requests for redaction of that exhibit or of the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I
all right, they're talking about
feel
him
that all
times in which
okay.
appellant tacitly
Now, this is the prosecutor who is now speaking, and they're saying, yo, don't give this motherfucker a new trial. Y'all made the right decision the first time. Let's stick with it.
admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told the appellant she was at the
If I may please the court, my name is Crystal Morgan with Morgan Lee.
security team saying, help, Tory shot Meg, 911. Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, Appellant said he would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told the appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said, he couldn't remember what they'd argued about. He wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party if voice recorded call. So turning to
So the prosecutor is really going into what they believe that Tory did a confession.
Tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5 RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontations clause claim just doesn't lie. And then...
So I think I've told you guys this when it comes to like appeals. The reason why good lawyers object to everything is that even if it gets overruled and, say you ask a question and it gets, your lawyer objects and it gets overruled, an objection is what's called you preserve a record, right? And you're making a record of you not agreeing with something that's happening. And in an appeal, that record will be taken into consideration because you've made a note that, I didn't like that this happened, but because we're in court and that judge is ruling this court proceeding, it happened anyway. So it gets to be reviewed because you brought up the issue initially.
I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that the defense counsel wanted more information about it. That was the time to raise it and to try to develop.
So I don't know if you get what the strategy here is for the prosecutors, that they're saying that, listen, these guys want a second bite at the apple. They want a second chance to try to say they're innocent, but they had the chance. They did not only did they not prove or not put enough evidence that the jury felt like they couldn't convict him beyond a reasonable doubt. In any procedural errors that were done, nobody raised a point to say, hey, this is unfair about certain things that it could be actually considered. So to be honest, let it be. That's what the prosecutors are saying. They weren't mad at the outcome. They weren't mad at how things are going until they lost. And the thing is, for example, if you make a choice, like, notoriously, do you want to push the trial back a little bit and interview the only sober person that day, which was Quan? Yeah, he would be admissible, and he would have to, sit there for the defense to direct examine him, but also the prosecutor were going to be able to cross examine him, and they didn't do that. They said, "Oh, we're good," and then the guilty verdict comes out, and they're like, maybe we should have." In court and in an appeal, they're not going to grant you an appeal because you're out of options and, you made a mistake. That's why they ask for it up front. Okay? Play a couple more minutes of this. Or a couple
more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies.
All right. Enough. Okay. Kind of going back to something we've covered before. I don't know if you guys seen this. So apparently Freddie Gibbs ran into Benny the Butcher while they were in London's airport. I think it's Heathrow. I think it's called Heathrow International. And let me Google Freddie, Benny. Okay. They ran into each other. And people, see this.
He's probably looking for us.
Okay. Oh, Wack is calling back.